I'm John Morgan. Thank you for trusting Morgan & Morgan with your case. As you get ready to prepare for your deposition, our goal is to make you as comfortable and prepared as possible. We will be here every step of the way. Over the next few minutes, our lawyers will explain the process and how the day will go. Thank you for watching this video. You're in good hands.
First of all, let me tell you what a deposition is. You come and sit at a table, and the opposing lawyer for the other side is there, and a court reporter will be there that'll take everything you say down, every single word down, and it gets typed up in a booklet form with a page and line exactly what was said. And the other lawyer is going to ask you the questions on the other side. We'll be there with you. We'll prepare you beforehand. You won't be there alone. But it's an important moment because the impression that you make during that deposition is going to have a profound impact on whether they want to go to trial with you or whether they want to settle with you. The reason is a couple things. First of all, they're judging you somewhat. I don't want to make you nervous. I don't want to put you on the spot, but I also need to talk straight to you. That's what's going to happen. So you want to come dressed, professional looking. You don't have to be in a suit and tie, but you want to, if you have it, that's fine. But you really want to come in like you were going on a job interview and you're wanting to make a good impression. They're going to, as soon as you leave, take a dictaphone out and they're going to dictate their report. The first thing that'll go in the insurance lawyer's report is going to be an assessment of your likability and your believability as a witness. I want to get into the substance of what you will be saying there and what you can expect. They're going to be asking you questions. You're required to answer them. The key is answering them straight, short, and honestly. I want to make something perfectly clear. The deposition is not your day in court. The jury's not there. The judge isn't there. Most folks want to tell their story. And they think, here I am in this official setting with a court reporter, and it feels kind of like court. And I want to tell my story. That's the wrong state of mind to be in when you come to deposition. If the case doesn't resolve fairly, you will get your day in court. And there will be a judge, and there will be a jury, and there will be an opportunity to tell your story. This is an opportunity for the other side to try to trip you up. You need to be mindful of this. They are the enemy. Don't let them sweet talk you into letting your guard down and forgetting these things we talked about. On the other hand, you don't want to treat them like the enemy. You want to be pleasant to them, not sappy nice. That wouldn't be sincere. When you get into the deposition, you can say yes sir or yes ma'am. I don't like when people answer every question yes sir, yes ma'am, because after a while it starts sounding like a canned, insincere answer. But a few of them, or if you don't understand, say, I'm sorry, do you mind repeating instead of, I don't know what you're asking me. Now you're combative with the enemy. You want to do it this way. I'm sorry, do you mind re-asking that? I'm not certain what you're asking. That's okay. You can ask him to repeat a question if you don't understand it. It's how you do it. Remember, you don't volunteer. They'll ask you a question. You'll think, well, they didn't ask me about this. Like they'll say, well, when you were hit, how did it feel? What did it sound like? Well, I was loud and it jolted and I felt pain right away. And you want to say, and I got out of the car and called 911. Don't. If they say, how did it feel? How did it sound in the car? Stop with answering how it felt and sounded in the car. They will probably, if it's a thorough lawyer, say what happened next. And you'll get a chance to say, I got out of the car and called 911. But if they don't, it doesn't mean that's left out of your story. It means they don't know that part of your story. And the less they know and the less informed they are, the less prepared they'll be at trial and the less likely they're going to be able to hurt your case. So here's the rule. Answer the question short and to the point and do not volunteer. It's that simple. Don't exaggerate. Don't say, it's killing me. It's ruining my life. The jury can figure that out. People don't like someone who they perceive as whining. And even someone in a wheelchair can cross the line with the jury like, good gosh, they're a big poor me person. Jurors respect people that are tough it up. Now, it doesn't mean you say, I'm fine. Well, if you're fine, we don't have a lawsuit. It means it's all about how you present it. Remember I said earlier, it's matter of fact, not whining. Never exaggerate. We can bring other witnesses to talk about how bad it is. You don't want to be a whiner.
Watch out for the tell me everything or list everything or is that all questions. These are questions that the defense will try to get you to limit your answers so that if you later claim anything in addition, they can say, you remember back when I took your deposition and I told you every way, I asked you every way that your back hurts, and I asked you specifically, is that all? Or I've asked you all the ways that you were limited by your injuries. Is that all? Is that all? Are there any others? And you didn't tell me any others, and you were under oath? Now you become a liar. So how do you handle that situation? Well, a couple of things. Number one, questions should never ever be answered with a yes or a no. They should always be answered with, that's all I can think of right now, or that's all I can recall. Leave yourself an opening. Otherwise, you will forever be limited only to those answers that you had in your head at the time of your deposition. Often we forget things. It's part of the human condition. Often more details come to us after the deposition. They just do. So it's extremely important to leave yourself an out. Leave yourself that ability. If you're answering any questions in more than 2 sentences, you're talking too much. Make the enemy keep asking, what happened next? 2 sentences, that's it. Remember that it's human nature, and this is big. It's human nature to try and convince others of the righteousness of our cause. Therefore, it's only natural that you will try and convince the defense lawyer of your case. Do not do this. The defense lawyer is being paid hundreds of dollars an hour not to believe a word that comes out of your mouth. As a matter of fact, they're trying to make you to be a liar. So for the enemy, this exercise is to get you to commit to answers that can somehow be disproved. Again, the defense lawyer will be very nice, very informal, very polite. He or she is doing this for a reason. Don't let your guard down. You must be very careful because at the same time, you need to be pleasant, likable, and believable. So you don't want to be off-putting. You want to be likable, but you don't want to give away anything, much less give away the farm. The likability factor is crucial because all of this can be played to a jury.
The defense is going to be asking you a lot of questions during your deposition. It's likely going to take a couple hours. While they're asking you these questions, you might be thinking, what does this have to do with my case? What does this have to do with the wreck or the incident that I was involved with, that I was injured in? This is what's called a discovery deposition under the law. What that means is the defense is allowed to ask you a very broad array of questions. The only questions they're not allowed to ask you are questions that we call privileged. If they ask you one of those questions, your lawyer will instruct you not to respond. But 99% of the questions they ask you, if not 100%, will not be privileged questions, and they will be questions that you need to answer honestly and truthfully. So remember not to get defensive. Not to ask questions. Well, why are you asking me that? Why is that relevant? Because unless your lawyer instructs you not to answer, it is a question they're allowed to ask. With that, remember, a deposition is not an endurance test. If you need to take a break to go to the bathroom, to gather your thoughts, to speak to your lawyer, that's absolutely okay to do. Just remember that before asking for a break, you want to be sure that you've answered whatever the last question is on the table. And I'll give you an example. They can't ask you, what day did the car wreck happen? And you say, can I take a bathroom break? You need to answer that question first. On the day of your deposition, make sure that you don't bring anything with you unless your lawyer instructed you to do so. No lists, no diaries, no journals, no cell phone with pictures. Leave that in the car. The defense lawyer is going to be asking you a lot of questions over a long period of time, spanning back years and years in your life. If they ask you a question that you don't know or you don't remember, it's okay to say, I don't know, or I don't remember. But you want to be honest and credible in those answers. So if you can make a reasonable guess, you should do that. For example, if they ask you the name of your high school, and the name of your college, and you say, I don't know, that doesn't sound very credible. Maybe you've forgotten the full name. Maybe they've changed the name since you graduated. But a reasonable guess to that question sounds more credible and more honest than simply, I don't know. Now, if they do ask you a question that you simply cannot remember, or you just absolutely do not know, like the speed of the other vehicle in a car wreck, when you answer I don't know or I don't remember, they're not allowed to continue to pry. They will have to move on.
This is very important. Never deny the truth. If you have previous injuries, admit them. If there's issues that are true, acknowledge them. The defense spends an incredible amount of money investigating you, your social media, your medical history, your employment, everything. It would be a horrible and potentially fatal mistake for you to fail to disclose any information thinking, oh well, they'll never find out. They will, and it'll ruin your case because you've just committed perjury. We can help you with any issue other than perjury. Remember, we'll be right there beside you the entire time. We will not allow any impropriety, and we will protect your rights. However, the law allows for very broad discovery, and be prepared for questions that seem irrelevant. Just because they can ask these questions on discovery does not mean we will have to deal with it at trial. However, if you were to provide a false answer, that may well make an otherwise irrelevant question become extremely relevant to your credibility and seriously damage your case. Remember that a majority of the questions being asked during your deposition, the defense already knows the answers. Again, it is a test to see if you're credible, believable, and tell the truth.